Did you get the discovery from the public defender?
No, Your Honor.
Why not?
Because
I mean,
at that time, we have a deal that
For
the
Pete's
clients will.
sake.
In this courtroom, fear meets justice. And today, nothing goes as planned. A man walks in, ready to plead guilty. But one problem destroys everything. No discovery, no documents, no facts, no plea. What starts as a simple guilty plea quickly turns into chaos, confusion, and a judge who's done playing games.
Courthouse case People versus Rashad Ahmad.
Ready, Your Honor.
The hearing opens with a deal on the table. 1 year misdemeanor, counts dismissed. No upfront jail. Everything is smooth. Until the judge asks the key question, do you still wish to plead guilty? Suddenly, hesitation. The victim is in. Cordy wants to say something. He approaches the bench. This plea is cracking before it even begins. The judge tries again, but the defendant can't explain what he actually did. Texts, Zaleel Alexa, call in 911. Nothing matches the charge. Nothing makes sense, and when the judge asks for the basic, factual basis, the story falls apart completely. I can't accept a plea. I don't have a factual basis. Boom, plea dead.
Good afternoon, Your Honor. Hassam Al-Qudsi on behalf of the defendant.
Rashad Ahmed.
I have a plea form in front of me that indicates that the defendant is going to be pleading guilty to attempted interfering with electronic communications. That's a 1 year misdemeanor. That's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay full restitution, and there's a sentence agreement, although the court, I cannot bind the sentencing judge. In this case, there's an agreement to no upfront jail. The prosecutor and defendants are agreeing to that.
That's correct.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Rashad Ahmed.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted interfering with electronic communications. That is a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court costs. Do you understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Still wish to plead guilty?
Sorry?
Do you still wish to plead guilty to this charge?
Your Honor, may I say something? Just something happened. The victim is here. Just want to let you know.
Okay.
And may I approach, Your Honor?
Yeah.
I'm sorry about that.
All right, sir, understanding the maximum penalties in this case, do you still wish to plead guilty to this charge?
Yes, sir.
And to that charge, how do you plead?
Yes, sir.
How do you plead? Guilty or not guilty?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Yes, sir.
Do you have any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
July 8th, 2025, at the location of 1480 Parkwood Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. What did you do what did you do that makes you think that you're guilty of the offense of attempted interference?
May I form the question, Your Honor? I'm sorry. Did you text her? You put a daughter via Zelle and text her? Did you do that?
After the court, you mean?
No. The judge is asking you, did you text her? Did you text her, send a text message via Zelle?
Yeah. Yes, I did.
Eh,
I don't know how that,
It's like, it was send money, it's not text.
Yeah, I know.
Yeah.
how does that, I don't know how I get to the charge.
This is the only electronic device that he attempted to do. He was texting her, giving her a dollar through Zelle so he can text her a message.
Sir, I'm just saying, whatever is being said to me doesn't sound like the offense.
Mr. Ahmad, on that date, were you with a Kimberly Chavaria?
Now, everything shifts. Defense wants a preliminary exam. Judge agrees, but what he discovers next pushes him over the edge. No discovery. Not from the prosecutor. Not from the public defender. Not from a 9 prior attorney. The judge is done. He calls out the missing reports, the missing 911 call, the missing paperwork, and slams down the decision. I'm not playing around with this anymore. Send the discovery. We're setting this for a real preliminary exam. A firm in-person date. September 9th, 2025 to 9 a.m. Bond continued. Case flipped upside down. Deal destroyed. Courtroom and...
He doesn't understand.
Like-
Who is this Kimberly? I want to, he's saying. He doesn't understand. Kimberly?
Yeah, he is somehow.
Ah,
Yeah,
she's asking you, you were with her on
Yeah.
that date?
yeah,
Okay.
And on that date, did she try to contact 911?
yeah.
And did you take the phone from her?
No, I didn't take the phone. Because she didn't try with the phone, she did try with Alexa.
Did you tell Alexa to stop calling 911?
Because Alexa said, just one time, because Alexa said she can't call 111 and start talking something else. That's why I stopped Alexa, because Alexa didn't, like, how we can say,
So you stopped Alexa from calling 911?
and not for calling, no. Alexa, after she called 911 and Alexa, it doesn't work for call 911. And they start talking, like,
Did you take her phone from her at some point?
no.
All right, well, I can't accept the plea. I don't have a factual basis.
Your Honor, so we do a preliminary exam? Your Honor, right,
Okay,
asking.
there will be a preliminary exam set. I will assume that all discovery is complete.
Oh, no, there was.
I will assume.
No, Your Honor, there was
Trial
no
can't
discovery.
accept the plea. Pardon?
There was no discovery. We didn't get any documents, police report and anything. Because at that time, we thought that we have
Well, why am I taking a plea if there's no this doesn't even make any sense. What?
Your Honor, in my file, discovery is tendered. You've sent over the media as well as the 911 call has been uploaded.
I never received it, Your Honor, 100%.
Was it sent to him? He's been the only attorney on the case, so.
There was another attorney before me, Your Honor. It was a public defender.
Did you get the discovery from the public defender?
No, Your Honor.
Why not?
Because
I mean,
at that
most-
time, we have a deal
For
that my clients
Pete's
will.
sakes.
Your Honor, I believe we sent discovery to both the public defender. I believe Ms. Stedman was also on this case prior, and the discovery was also sent to her.
And you're saying from neither prior attorney did you get discovery?
No, Your Honor.
Can you send it to him now? Because I'm setting this for exam. I'm not playing around with this anymore. Send a discovery to them. This will be set for preliminary examination in person, September 9th, 2025, 9 a.m. That's before me. I'm gonna quit playing games. Bond continued.
Thank you, Your Honor.
And that's why, in this courtroom, if you're not prepared, the judge will stop you cold. If you want more real case breakdowns like this one, hit like, share and subscribe, and dive into the next video waiting for you on the right.